So first of all, I would like to welcome you all to the Sorbonne for this second event co-organized by ICC France and l'École de droit de la Sorbonne. And I deeply thank the ICC to have accepted to organize this event with us. It is, as I said, the second event we are co-organizing with ICC France. Last year being the 100 years anniversary celebration with Claudia Salomon as a keynote speaker. And for this second event, for the 2024 PAW, we decided with Emmanuel Buteau-Stub, who is over there, to focus on arbitration and sanctions. So this choice has been made for at least two reasons. First one is that ICC France has issued a report related to the impact of sanction on French and European companies. That is the report. And I highly recommend its reading, not just because Noël Donouard and myself, we have been heading the task force that redacted this report, but because it is a very good report, I must say. So feel free to read it if you need to. The second reason is that it is undoubtedly a core subject today, arbitration and sanction. And just as a reminder, on the 23 February 2024, the Council of the EU has adopted a 13th set of restrictive measures against Russia and Belarus. And the sanctions program taken by the EU, but also by the UK, by the US, by Switzerland, by Canada, by Japan, Australia, New Zealand, South Korea, is the largest ever. And these measures have strong consequences on international contracts, trans-border transactions between the East and the West, assets, payment, and so on and so forth. And all this gets us to arbitration, being the usual and the most common way to solve international commercial disputes. Arbitration is now more and more frequently confronted with sanctions. We see it on a day-to-day basis in the news, in the GAR, in IA Reporter and the like. Of course, it has to be said that the confrontation between arbitration and economic sanctions, embargoes, does not date to the Russian invasion of Ukraine. There have been in the past arbitral cases involving UN sanctions, for example, UN sanctions against Libya, for example, or US sanction against Iran, etc. But today, with the Western sanctions against Russia, we are talking about a very different scale. The impact on the arbitration practice is, let's say, structural, not just a new issue arising out in the world of arbitration. So this is why, together with ICC France, we wanted to touch upon this hot topic. And as you might have noticed, while going through the PAW program, we are not the only ones. I counted, there have been 7 events that are more or less related to the same subject during the PAW. But be sure that you have made the right choice. This event is going to be the most impressive one. And for a very simple reason, which is our outstanding speakers. Without any doubt, we have the chance to have with us academics and practitioners having a huge experience of this very precise topic of arbitration confronted with economic sanctions. So let me briefly introduce them to you. We have Marie Stoyanov, who is a partner at Allen Overy in Paris. We have Sylvain Bollet, who is a professor in this university, in the Sorbonne Law School. We have Emmanuel Jolivet, who is the General Counsel of the ICC International Court of Arbitration. We have Gabriele Ruscala, with a council in Liedekerk in Brussels. And then we have Marco Torcello, who is a law professor at the University of Verona and a partner in Arblit, a boutique arbitration law firm in Milan. So these are our speakers, and let us now move ahead to the different subtopics we would like to address today. So these different subtopics are, we will speak about sanctions and arbitral tribunal constitution. Then we will move to sanctions and jurisdiction. Then to the Russian countermeasures. Then we will address impact of sanction on the merits and impact of sanction on the enforcement of awards. So without any further delay, let's talk about the first subtopic, which is sanctions and arbitral tribunal constitution. So I would like to maybe leave the floor to Emmanuel Jolivet as a starter for this very first topic. So Emmanuel.
Thank you, Matthias. Thank you all for being there this afternoon. So, as it was just said, international sanctions are now a common feature of international arbitration. You know very well that a number of factors trigger sanction issues. Parties, of course, that's been mentioned, but there are also there is also a need to look at related entities. So what is the link between parties and other entities that could be linked somehow to these entities? For example, shareholders, suppliers. Sanctions can also have an impact on arbitrators, of course, on experts, neutral. Countries are, of course, a key element to look at in any arbitration proceedings. Well, countries and territories, should I say. The sector of activity, the subject matter of the dispute, so a number of elements. So sanctions are complex, as you know, because we will need to look at all these elements. So there is a network, or a patchwork, should I say, of factors that one should consider. To give you some statistics, of course, it's only based on my experience, but you will see the importance of the matter in terms of figures. This year, in 2024, 25% of new cases, so cases filed since the beginning of the year, involve sanctions. 25%. If you look at the current active caseload of the organization, of the International Court of Arbitration, slightly less than 500 cases today involve sanctions. So it's more than 25%. So 25 is a lot. It means that when you are dealing with international arbitration as an arbitrator, as a counsel, the likelihood to have sanction issues in your case is relatively high. What we have seen recently is, of course, an increase in the number of cases involving Russia, but traditionally we always had a high number of cases involving Iran and Venezuela as well. Few Cuban cases, and well, I should mention it because it's interesting, but because these are really problematic. 3 North Korean cases which have been blocked for decades, and those ones can't really move. But we will see that it's not the case for the others. So this leads me to maybe the first subtopic of my presentation, which is really important because we see sanctions are important. So what? How should one deal with international sanction? The first thing to look at is there an institution to administer the case? Or is there an institution that could be contacted for information, for example? So it's not enough to have an institution, but we should know the position of that institution. So do the arbitral institution has a position, or do arbitral institutions have a position in general? That's interesting to see. A number of institutions do not express any view on the matter, and keeping silent, not expressing any view is already a position. But others have issued some kind of general principle, guidelines, notes. So there is a bit of information that could be looked at and studied. The next question is, if there is a position, what is the authority of this position? At what institutional level has the position been adopted? We have seen in practice that this is also a serious issue. Who answered the question? Is it the case manager? Is it the secretary, the help desk? Is it the president of the court? Is it the CEO of the organization? In any company, if you negotiate a deal or mergers and acquisition for a company, you will check delegation of authority, who has authority to sign the deal. Strangely enough, in those circumstances, it's almost never checked. So that's something to keep in mind. Specificity of international arbitration, maybe, but you need to look at the person issuing the position. How is the position communicated is also important. Has the institution issued some notes, guidelines? Is there anything in the rules of the institution? For example, you know very well that the ICC has issued a note on compliance explaining how cases involving sanction would be dealt with, but that's also something to consider. And of course, the consequences on the administration of the proceedings is particularly important. Is there a specific team or group of persons in the institution in charge of handling those matters or not? So do you have specialists in the institution dealing with that or not? And of course, this is related to the risk appetite of the parties and the arbitrator to work with an institution or not. Now, because I have 1 or 2 minutes left, turning to the second topic, the appointment of arbitrators. Most arbitrators are appointed by the parties, and a few, the remaining are appointed by the institution under the ICC rules. It's the International Court of Arbitration that will appoint the arbitrators if they are not appointed by the parties. And here, once again, the role of the arbitral institution is at stake and should be considered. Who in the institution will deal with the matter? For example, would a US consul be allowed to appoint or participate in the appointment of an Iranian arbitrator? Could the institution assist the parties, the arbitrators, sometimes the consul, to get visas for hearings, for example, or to organize hearings? So there is a lot of impact on the choice of arbitrators, also in terms of delays, payment issues. We will come to that. But if you have a case, for example, and we had a case in the past, or a number of cases where you had Venezuelan party, where the parties appointed American arbitrators, this created a number of issues. If they had appointed a French arbitrator, the solution would have been different. So this is something to consider. I'm not saying that you should always appoint French arbitrators and not Americans. That's not the point. But you understand what I'm trying, the idea I'm trying to convey. So now, going to payment issues, and I will stop there. This is particularly interesting. There are a lot of fake news about payment issues. Everyone has heard the horror stories saying it's impossible when you have a Russian party or Belarusian or an Iranian, your case is stuck, it's impossible to proceed. when you look at statistics, it's almost never the case. There are a number of precautionary measures that you should take. I'm not saying that it's easy, but statistically speaking, very few cases, almost no cases today are blocked, with the exception of the North Korean. But Russian cases, Venezuelan cases, Cuban cases, Iranian cases, they are not blocked. Of course, you need to be careful. You need to consider whether US or European sanctions are applicable, for example. It could have an impact on the choice of the currency to collect the payment, to pay the arbitrators. But in terms of statistics, only 1.4% of the payments, the aggregate amount of payments have raised difficulties and rejection by the banks. 1.44% of the total amount of cases involving sanction have been rejected by the bank. So it's an extremely small amount, let's say 1.5% of the total amount. So it means in practical, and in these rejections, I should say, that sometimes the amount has been rejected because the parties paid with the wrong currency. You are asked to pay in euros. If you pay in ruble, the payment will be rejected. It seems obvious. If you pay the wrong party, the payment will be rejected as well. So in this 1.4%, you have all these cases. So in fact, in practice, it means, in practical terms, that you almost never have a problem if you follow the advice given by the arbitral institution. So I will stop there and take questions or give the mic to another speaker.
Thank you, Emmanuel. So I'm quite impressed by this percentage that you've mentioned, 25%. That's a lot. So you touched upon three topics. The first one being the position of the institution. There have been this statement from the ICC and CIA and the Stockholm Chamber of Commerce in 2015, I think, related to the impact of the EU sanctions against Russia on international arbitration administered by EU-based institutions that could be mentioned. And you mentioned also the issue of the appointment of arbitrators and the payment issue, which is not an issue, if I understood correctly. So I don't know whether other panelists would like to react on these three different topics. Marco.
Okay. Well, thank you. And I'll go first to break the ice. Also because I have a comment which somehow is also a question, so it's maybe the other panelists can answer this question. Because considering the stage of the constitution of the arbitral tribunal and how the arbitral tribunal can actually operate, I think one point which has not been addressed, but which may be of great interest, would be related to the seat of the arbitral tribunal and the possibility of changing the seat as a result of the applicability of measures and sanctions. I think it's a contractual question in the first place, whether the consent expressed by one of the party or both parties is still actually effective or can be somehow withdrawn by the party that expressed that consent. And then the suppletive rule, which would come into play, might be of great relevance. One might refer to Article 20 of the model law that, say, failing an agreement, the arbitral tribunal should make the choice of the seat having regard to the circumstances of the case, including the convenience of the parties. So that could be invoked. Under the ICC rules, it's the court, and there's no reference to the convenience of the parties, but I think there is still room to possibly change the seat, which would actually have a very significant impact on how the whole mechanism of the sanctions would operate.
Do you think it would be the seat could be changed without any consent from the parties?
That is the question. But there are rules that provide for suppletive rules that allow the arbitral tribunal, absent a consent of the parties, absent an agreement of the parties, to choose the seat. Or there are the ICC rules allow the court to determine the place of arbitration. So if we accept the premise that the agreement is somehow unenforceable due to the supervening change of circumstances, the sanctions, then we are back at day one, where there's no full agreement, or there's no valid agreement, and therefore there is a substantive room which grants to the arbitral tribunal or to the institution the power to determine the seat. And that could be a very powerful tool to actually make arbitration proceedings that would otherwise create a huge problem because of the location of the seat suitable to be working in a smoother manner.
Thank you, Marco. Marie.
I mean, you're anticipating on what I was going to explain about the Lugovoy law, because that is precisely, at least in the first draft of the bill, the possibility for the Russian party unilaterally to revoke its consent to arbitration, very much amounts to that. What I've seen so far is changes to the venue, not the seat of the arbitration, but the venue, of course, because you do want to ensure when you're on the other side that your award will be as unimpeachable as possible, and therefore everyone can travel to the place of the hearing, and arbitrators are very keen to do that, even without being prompted by the parties. There's been, as you know, an unfortunate case of a change, completely different context, change of seat between Spain and France that hasn't ended very well. So I think arbitrators may be reluctant to repeat that experience. Sure. I think also, at least the Russian approach would be to say, it's not just the seat that makes the agreement unenforceable, it is the entire system, hence the justification for the Lugovoy law. And recent experience in the Russian courts show that even those countries that are not on the list of the offending countries, according to Russia, Hong Kong, just to give an example, are not considered to be safe by Russia. Hence the issuance of anti-suit injunctions against arbitration seated in Hong Kong on the basis that Hong Kong law is too close to English law. So I think you would get a sort of creeping, ever-growing list of countries that are not safe, and then how far do you go in accommodating one party without endangering the finality of the award, indeed the thought that the parties have given to a seat in an arbitration-friendly jurisdiction. So I would have real issues with an arbitrator, the court at the ICC, overriding the parties' agreement, but I may be too legalistic. I don't know.
Thank you, Marie. Gabriele, Sylvain, do you want to react? Gabriele?
No, because I wanted to follow up on what Marie just said. There is not only the case of the Paris-Madrid change of seat, but there was another one previously from an ad hoc arbitration from Sami Ouahabi. We discussed that in our event. So I think that once the parties decide agreed on a seat of arbitration in an arbitration agreement, then either the court or the institution, the court of the institution of the arbitral tribunal may find itself in a very difficult position to change the seat without the consent of the parties. And I think that if they do that, they can actually infringe a basic principle of arbitration, which is consent, basically.
And even changing the seat will not solve the problem for the institution itself.
For sure. Yeah. Sylvain?
Actually, as a matter of principle, I believe it's possible to change, possibly the place of the seat, and more likely the place where, for instance, the hearings will take place. I remember that there was some very interesting work by Pierre Lalive on this topic, but I'm not entirely sure this would be very appropriate in the context we are considering. I would need to think about it.
We addressed the first subtopic that had been raised by Emmanuel, but regarding the appointment of arbitrators, There is a question that I would like to ask is whether, let's say, as a European citizen, if you're sitting as an arbitrator, is it mandatory for you to apply the EU sanctions, for example? Or if you're a US citizen sitting as an arbitrator and you're facing a case where the US sanctions are involved, so are you obliged to apply the US sanction? Of course, that is a very important issue for the parties. I don't know whether one panelist or the other would like to react on this.
Yeah, actually, I think what you have just mentioned is really a key point, and there is this very strong consideration, the risk for arbitrators to be sanctioned themselves if they fail to give effect to sanctions. And as a matter of fact, not all arbitrators are equally exposed to this risk. Under the EU rules regarding sanctions against Russia, an arbitrator might be sanctioned if he sits in a member state or if he has the nationality of a member state. And I think, as we shall see later in this conference, it's a key element when one examines the various issues raised by the interaction between international arbitration and sanctions. And maybe I have a question regarding what institutions should do. I have in mind the case of arbitral institutions who are committed to comply with European sanctions, such as the ICC. In a way, if they favored the appointment of European arbitrators, this would increase the chances that arbitral tribunals comply with EU rules, wouldn't it? Especially in the case where the seat is not in a member state. Because when the seat is not in the European Union, it seems that only European arbitrators might be sanctioned. So I wonder if arbitral institutions would favor the appointment of European citizens, you know, or if they would remain neutral in this respect. I suppose it's not an easy call, and I suggest no answer. I raise the question.
Well, I have no difficulties to answer. The institution stays neutral. The perception of the parties could have an impact, of course, but what is really difficult for institution is they are subject to a number of laws, regulations, but also practices of the arbitration ecosystem, if I may call it like that, including how banks and insurers will react. And if you have a case where, for some reasons, sanctions are involved, to use a loose terminology, very often the banks will start to make some inquiries, your insurers as well, and you will be obliged in some ways to comply with sanctions. Even if legally it's not binding, in practical terms, it's extremely difficult. We had cases where, of course, after discussion with the parties, with the arbitral tribunal, we were obliged to comply with a number of, I would say, conditions or prerequisites set by the banks, which were, which were clearly the result of a wrong interpretation of US and French regulations. But in practical terms, it was the only possible way to make progressive payments and appoint arbitrators. Because you can always, well, you can very often appoint arbitrators, but if they can't be remunerated, it's much less attractive for them. So that's really the issue. In practical terms, most of the time you're obliged to comply with the sanction regime applicable, or not. But
I think Marie would like to react on that.
I just wonder whether well, I would at least make a small distinction, maybe quite a fundamental distinction, between an arbitrator not complying with the sanctions regime in the sense of not asking for a license, for instance, before accepting a mandate and receiving funds directly from a sanctioned entity, and an arbitrator in its judiciary capacity taking a decision as to whether sanctions applied in the case at hand, and if so, in what way, to what extent. To me, there is no question of lack of compliance with the sanctions regime, and therefore a risk of the arbitrators themselves being disciplined in their judiciary capacity. And I think I'd be quite concerned if, certainly an EU member state, we're starting to imply that disagreeing even with the official interpretation, whether as a judge or an arbitrator, would make you subject directly to sanctions. Again, given some pronouncements of the ECJ, even in other cases, that would take us very far down the rabbit hole.
Any other reactions? No. You might have heard that at least one very famous arbitrator has been sanctioned by Russia recently, but that was not because he was sitting in an arbitral tribunal anyway. I think we'll close this first topic, and we'll move to the second topic, which is related to sanction and jurisdiction. And jurisdiction being heard as lato sensu, encompassing arbitrability and claims admissibility. So there are some case law related to this issue, like the old Ficantieri case from the Swiss court, like a case from the Court of Appeal of Quebec in 2003, and some recent case in Paris from the Paris Court of Appeal called Armanenti case. But Gabriele, maybe you could enlighten us on this issue.
Yeah, thank you very much, and thank you for the invitation also to speak on this panel. So I will start from the Italian case law that Mattias just mentioned, because gives you an idea of how Italian courts have applied completely different standards from any other courts around the world, including the Swiss Federal Tribunal, the Cour d'appel de Paris, and also the Cour d'appel of Quebec in similar cases, some of them also connected. So the Fincantieri saga started several years ago, in 1989. There was a contract between the two Italian companies, and that entered into agency agreements with an agent for the conclusion of several contracts with the Republic of Iraq. The dispute arose in 1989, and the agent started an ICC arbitration, which resulted in an interim award in which the arbitral tribunal declared having jurisdiction over the dispute. And so the two Italian companies requested, on the one hand, the setting aside of the interim award before the Swiss Federal Tribunal, on the basis that the subject matter was not capable of settlement by arbitration because of the commercial embargo that was put in place by the United Nations on Iraq. And also under Article 5.2 of the New York Convention, the award would not be enforceable in other jurisdictions for the very same reason. So the Swiss Federal Tribunal dismissed the request of the Italian parties to annul the arbitral award, the interim award, and at the same time the Italian parties started parallel proceedings before the Tribunal of Genoa against the agent and the Republic of Iraq, requesting the tribunal, so the court in Genoa, a declaration of termination of the concluded contract, the performance of which, on the basis that the performance of which had been rendered impossible by the unlawful conduct of the Iraqi state due to the invasion of Kuwait, and also a condemnation of the respondents to pay damages as a consequence of this unlawful conduct. The responding parties, of course, raised objection as to the inadmissibility of that specific demand before Italian tribunals, for the simple reason that in the agency contract, there was an arbitration agreement and that therefore that dispute should have been heard by an arbitral tribunal. So in 1992, a couple of years after, the first instance tribunal in Genoa took the right decision. And so it said, it didn't elaborate much on the issue, but said there is an arbitration agreement. The matter that is being requested by the party is not a matter that is directly linked to any elements under sanctions imposed by the United Nations. So the matter was actually decided in a pretty correct way. Arbitration agreement, the arbitral tribunal has jurisdiction, the matter being arbitrable, or in any event, it's up to the arbitral tribunal to decide whether or not the matter is arbitrable. There is an appeal, and a Court of Appeal of Genoa decides in a completely different way. It reverses the decision of the first instance tribunal and states that the parties could not have recourse to arbitration because they did not dispose of the rights which were the object of the dispute, for the simple reasons that those rights were challenged by the existence of embargoes imposed by the United Nations. In a similar path, the Italian Court of Cassation in 2015 took the same decision and went actually a bit farther and found that the arbitration clause was null and void. We are again in a situation, in a case where the Iraq government is involved, and of course there is the embargo of the United Nations that is still underlying. So the Court of Cassation of Italy found that the arbitration clause is null and void, and the dispute involved economic sanctions was inarbitrable, so took jurisdiction over the case, and stated that basically the disputes or that an arbitral tribunal could not have actually the authorities or the jurisdiction to rule over disputes where the rights of the parties are not freely, or whether the rights of the parties are not freely disposed by the parties themselves. Why? Because the embargoes actually had this negative impact on the rights of the parties. And so it based its decision on the Article 5.1 and Article 2.1 and 2.3 of the New York Convention. Now that is the approach of the Italian courts in that specific circumstance, which means that the matter becomes inarbitrable because the parties do not freely dispose of their rights to go to arbitration, because of the existence of these overriding mandatory rules that are the sanctions imposed by the United Nations. And the same would actually apply in case of European Union sanctions. Now, if we look at other courts, it may be, for instance, the Cour d'Appel de Paris, but also the Swiss Federal Tribunal. As I mentioned, the same matter was actually sent to the Swiss Federal Tribunal. The Italian companies wanted to or requested the setting aside of that interim award I mentioned before, and the Swiss Federal Tribunal rejected in total that request, saying that the matter was indeed arbitrable, and that the arbitral tribunal had jurisdiction to decide over the arbitrability of that dispute. The same happened in Paris more recently, where the Court of Appeal of Paris said again that the existence of an arbitration agreement leads to the arbitral tribunal being the judicial authority to decide over the arbitrability of the dispute, and that the existence of the sanctions, being them from the United Nations or the European Union, does not attack the arbitrability of the dispute that remains in the hands of the tribunal. In a very recent decision, and that was a decision of the Cour d'Appel de Paris in 2020, I think, the court took again the same exact position, saying the existence of embargoes, it actually defined embargoes imposed by domestic law, so unilateral embargoes, by European Union laws, and also by the United Nations. But he said that in any event, the existence of embargoes imposed does not lead the matter to be non-arbitrable before the tribunals. So there is a clear trend, on the one hand, from, I would say, more liberal jurisdictions, such as France, Switzerland, but also Canada, to have an approach that is, of course, in favor of arbitration, meaning there is an arbitration agreement, that arbitration agreement remains in the hands of the arbitrators, who may at the end decide that the matter is either inarbitrable, if they consider so, or that the claims brought by the parties are inadmissible because also of the existence of sanctions imposed by multilateral bodies. Different, of course, is, as I described, is the case of Italy, where the approach is much more conservative, and the courts have retained jurisdictions even when, of course, there is an arbitration agreement, which, of course, appears violating all the basic principles of international arbitration. And I can say that because I'm Italian, so I can take a stand on that.
Thank you, Gabriele, and thank you for this very precise overview of the case law from different countries. So I understood that the clear trend, as you said, is that this issue remains in the hands of the arbitrator, and the principle of competence still applies, even if the arbitral tribunal or the arbitration clause is facing sanctions. But I was wondering whether there might be a distinction to draw between UN sanctions being worldwide and unilateral sanctions, even though by unilateral sanctions we could mention the regional sanctions like EU sanctions or sanctions for a specific country. Do you think this could explain the decision of the Italian court? Because if I understood well, the Italian court faced UN sanctions and not unilateral sanctions.
I'm of the idea that even in case of European Union sanctions, the decision would have been similar.
Okay.
Because, and we discussed that before with Marco, because the approach would have been the same. So there is an overriding mandatory rule, and per se, the Italian legislation provides for the fact that if the rights are not freely at the disposal of the parties, then the arbitration agreement becomes invalid, basically null and void, and therefore it could not be enforceable. It could not be used, actually, by the parties. Yeah.
I don't know what are the views of our other panelists. Marco, you want to say something?
Well, yeah, I guess as the other Italian sitting on this panel. And of course, I fully agree with Gabriele, but I'm not convinced that it's, and maybe regrettably, it's only an Italian attitude. I think when we look at arbitration, we usually divide the world in arbitration-friendly jurisdiction, and France and Switzerland and certainly and many others. And then there are some in the blacklist, and Italy, it's probably in a gray list. We're trying to improve a little bit, but we're not alone. And I think that kind of attitude, it's even in the European Union, it's not necessarily unique about Italy. I think it goes back to the issue of the Ingmar case in choice of law, and the possibility of expanding that approach also to the dispute resolution agreement, and saying, well, if and even the existence of an arbitration agreement is still subject to a safety valve, which is Article 2.1 of the New York Convention, and Article 5.2 but 2.1 in particular, which is reserved to the state. That is a state law. It's not intentionally not really unified. And states use that safety valve in different ways. Again, I'm not supporting that solution, but it seems to me that it's coherent with solutions that have been taken in other areas, like commercial agency agreements in an arbitration where the characterization of the provisions as overriding mandatory rules has justified Italian courts, but also Belgian courts, German courts, to overlook arbitration agreements or choice of forum agreements and retain jurisdiction without waiting for the second look stage, the stage of recognition and enforcement, but just on the basis of a prognosis. If the case goes to arbitration, or if the case goes to that non-European court, the European law will, or the overriding mandatory law will be disregarded in that case. So there is this idea of the effective principle to ensure the application of European law, which is the tool which is used to retain jurisdiction in this case. Maybe the question is whether that effect utile, which is applied regularly with respect to commercial agency, and the argument is, well, the commercial agent will never go to West Virginia, as in the German case, because he knows, or she knows, that it will never be granted the indemnity. But that does not necessarily apply in the same manner. So there might be a different analysis as to whether it makes sense to anticipate the analysis at the stage of the determining or retaining jurisdiction contrary, in contrast to an arbitration agreement, and it's not instead possible to simply wait the way in which the arbitration agreement the use of arbitration agreement is made by the arbitrators, which would make probably jurisdiction like Italy and other jurisdictions more arbitration friendly. But I have the impression that this is an approach which is not exclusive of Italian courts, which is probably the majority of the EU member state would go in that direction, which is a problem. I fully agree with that.
But if I understood well, you think that in some ways it is legally grounded. You could say that that is legally grounded, this solution in some way.
Well, not really, because if the starting point is Ingmar saying, well, the choice of law cannot be enforced because this is an overriding mandatory rule. But the overriding mandatory rule, justification of applying the rule, has a legal grounding in Article 9. There's nothing explicitly conferring jurisdiction on courts on a similar basis in the Brussels regulation, and probably also in the jurisdictional rule of the individual member state. So it's questionable that this prognosis can actually be done the way it is done. So the legal argument is not a very strong one, because there is no strong legal argument to retain jurisdiction ex ante. Okay. So I think that there would be an argument to plead in favor of a different solution. However, the trend seems to be strongly in that direction in several jurisdictions.
Okay. Marie, you would like to react?
Yeah, just for me, the point is a trust in the arbitrators. So if we have a case that has a contract that has the arbitration agreement, then the jurisdiction is for an arbitral tribunal to decide over the matter. The question is, why don't we trust the arbitrators in the application eventually of these overriding mandatory rules? They could also apply them.
Of course.
So if there are sanctions, if there is European Union sanctions, they may be the ones applying those specific regulations and those principles in the arbitration. And national courts do not have, I mean, in my view, they don't have any right, but they don't have, they shouldn't do it, because there are already, the judges of the dispute are actually the arbitrators that apply, if they retain it appropriate, the overriding mandatory rules. And if they don't apply, and then there is an issue, it will be for the judges at the enforcement or setting aside stage to decide whether or not the principle were respected, in my view.
Marie?
After your explanation, Gabriele, initially I was going to ask whether Fincantieri is still the position of the Italian courts, but you quickly confirmed that, much to my dismay. I am quite struck, but as you say, by the lack of confidence in the arbitrators, but also the confusion between arbitrability and an award, the enforcement of which may be contrary to international public policy and therefore be either set aside at the seat or whose enforcement may be refused. There are mechanisms for that have been provided for in all of our systems. And even as we know, the ECJ isn't going as far as to say mandatory provisions of EU law are not arbitrable. What I was wondering as well, I don't think we have the answer yet, but let's imagine in the case at hand, and we'll come on to that we have an Italian party that has contracted with a Russian party. Sanctions apply whether to the Russian entity or to the project that is underlying the contract at hand. Clearly, the Russian courts would say, we now have exclusive jurisdiction. I think, based on what you just said, it would be very difficult for the Italian party to say, no, you don't, an arbitral tribunal has jurisdiction, because the Italian courts take the view that the arbitration agreement has become unenforceable, very much in line with the Lugovoy law. So it's quite interesting that an EU member state goes in the same direction as Russia on that one.
Actually, when it comes to sanctions against Russia and the EU sanctions, there is also another tool, the tool of inadmissibility. And in fact, it might lead to a comparable result. According to, it's not a provision that is specific to arbitration, but according to Article 11 of Regulation 833, 2014, the dispute can be decided, but only in one sense, because it is prohibited to satisfy a claim relating to a contract affected by sanctions, as long as it's brought by an entity which is targeted by sanctions or by a Russian party. So I think it's a very important point. And in practice, such claims, I believe, will have to be held inadmissible by arbitrators. And of course, in practice, it's likely to be a strong reason not to initiate arbitration at all, right? And the issue this might raise is that of compatibility with fundamental rights from the perspective of EU law and arguably the perspective of European lawyers. This inadmissibility rule is legitimate because it's in line with the logic of sanctions. But in practice, some might say that it amounts to depriving the potential claimant of its right of action. And this objection was raised in at least one case, we know. So I think arbitrators should also be ready to consider this issue with attention. And the question would be, what would happen if an arbitral tribunal found that there was a breach of the fundamental right of a party? That's a question. And you might think, of course, they should not give effect to sanctions then. But we must also keep in mind that arbitrators might also bear the risk to be sanctioned themselves. So it's really not an easy task to address these issues, I believe. And there might be a difficult alternative for arbitrators.
Any other reactions? Okay, so then we will move to the third topic, and after this third topic, we could have a Q&A session if the audience wants to react. This third subtopic is related to the Russian countermeasures that has been taken following the EU program, sanctions program. And as you might know, there is a 2020 law from called the Lugovoy law that has been mentioned already by Marie. And this Lugovoy law, Marie, could you tell us a little bit about it?
Yes, of course, and let's maybe start with the position before the Lugovoy law. Perhaps unsurprisingly and quite reassuringly, the position in Russia was very familiar to our position, i.e. the Russian courts would deny jurisdiction if they were seized of a dispute unless and until the arbitration agreement was manifestly null and void, inoperative and incapable of being performed. So it all sounds very familiar. There were lots of pronouncements including the plenum of the Supreme Court, that were very careful in applying this in accordance with what international parties would expect. Of course, the sanctions come in and the Russian Federation decides to take countermeasures to protect the rights of its citizens and its corporations and ensure that they have a fair access to justice. On the basis, also the explanation to the bill provided, that it was very difficult for sanctioned Russians to get to the right venue, instruct, counsel and participate freely, completely in a case where their interests were at stake, not to mention that, of course, sanctions had to be applied unilaterally, and in those circumstances you could not expect justice to be done in a forum that was outside Russia. And so the Lugovoy law, by the name of the MP that introduced the law, changed the Code of Arbitration Procedure to introduce two different but linked provisions. The first says that basically any dispute that involves a sanctioned entity or that relates to sanctions now pertains to the exclusive jurisdiction of the Russian courts. There was a first draft of the bill that said the Russian party could unilaterally revoke its consent to arbitration or modify the dispute resolution clause. That wasn't retained. It's now simply exclusive jurisdiction of the courts. The second aspect to the law is an ability for the Russian party to apply to the Russian courts and ask for anti-suit or anti-arbitration injunction, i.e. a prohibition to initiate or continue proceedings in a foreign forum or arbitration outside the Russian Federation. Now, to some extent, some may have sympathy with the position the Russians found themselves in, being exposed to what they would say is unfair justice, prejudged questions, and say they had to protect their interests. What this has led to, though, is also an evolution, which I think is interesting, of the case law in Russia. If we just look at the anti-suit injunctions, for instance, in Russia, the lower courts initially insisted on there being evidence that the Russian party could not access justice abroad. They were put right by the Supreme Court, said, you've misunderstood the provision of Russian law, that is automatically established. The Russian party doesn't need to prove that they're denied access to justice or that it's more difficult. The simple fact that they are being called to appear in a foreign court or an arbitration outside Russia, that suffices as a basis for an anti-suit, anti-arbitration injunction. The Russian Federation then also issued a directive listing the countries that were particularly offensive because they had issued sanctions. And so by definition, any court in those countries or any arbitral institution or indeed arbitration seated in those countries was considered to be unfair and therefore deserving of an anti-suit or anti-arbitration injunction. As I believe I've mentioned earlier, there are now jurisdictions that have not issued sanctions against Russia that are considered unsafe. Hong Kong, in one of the cases that I will come to touch upon because it has given rise to a number of anti-suit injunctions in the English courts, an anti-arbitration injunction was issued against the parties who were litigating and arbitrating in Hong Kong on the basis that Hong Kong was just too close to the United Kingdom to be completely fair as well. And yet, for those of you who are involved in disputes with Russian parties, we often think of Hong Kong, Dubai as a safe venue, at least, for arbitration hearings. So maybe Hong Kong is now off the list as well. So those parties that are faced with those proceedings in Russia, as you will know from the news, it's no secret a lot of banks who had issued bonds, advance payment bonds, performance bonds, that were governed by English law, dispute resolution calling for arbitration in Paris, are being sued by the Russian beneficiary of the guarantee on the basis that they refuse to pay under the bond because of the sanctions, even on first demand guarantees. I think it's fair to say that chances of the foreign parties prevailing in Russia are extremely slim, and so we can anticipate, indeed, one party has already been ordered to pay both the debt owed to the Russian party, but also damages in quite a high amount. So those international parties were confronted with the issue, what do we do now? There's very little we can do probably to avoid a negative decision in Russia. Can we avoid that spreading out, being enforced outside Russia? And so what are the options? Well, one of the options when you have an arbitration clause, ICC in this case, is do you go to an emergency arbitrator and ask the emergency arbitrator to issue an anti-suit injunction? May not get that enforced in Russia. Indeed, it isn't enforceable in Russia, but it may be enforceable elsewhere if a Russian court decision were to be enforced in that other jurisdiction. The difficulty with an emergency arbitrator decision is it's not an award. And even if some institutions explicitly provide for the ability of the arbitrators to call it an award, and some jurisdictions may treat it as such, others won't, simply because it does not finally dispose of part or the entirety of the dispute, and certainly that would be the case in France. And so regardless of what you call an emergency arbitrator decision, it may not be enforceable in very many jurisdictions, and on any view, it may be then reviewed by the tribunal once constituted. So if you think anti-suit injunction, of course, you think of England. They're very used to those long history, and certainly ever since the Angelic Grace case, it's very firmly established on what basis those can be issued. The wrinkle here, of course, is the only link to England is the governing law of the contract. The seat of the arbitration is not in London, it is in Paris. None of the parties to the dispute are English, and we're even talking about assets in England. And there have nevertheless been a series of decisions, including at Court of Appeal level, that have decided, subject to the Supreme Court, which has accepted to hear the case in accelerated fashion, and decisions should come before the summer, that on the basis of, not of the Arbitration Act, but Section 37 of the Senior Courts Act, English courts do have jurisdiction, personal jurisdiction, on the basis of the applicable law, and that it is just and convenient to issue an anti-suit injunction in the circumstances. One of the factors, and Mathieu knows it very well, was what was the position under French law. The English judges in all cases were very interested as to whether a French judge would A, assume jurisdiction over an application for anti-suit injunction, or was it so abhorrent to our system that A, an anti-suit injunction would not be enforceable in France, and B, by agreeing to arbitrate in Paris, the parties had also implicitly agreed that they would not have access to anti-suit injunctions. There's one judge that in my view, found quite wrong on what French law says. The others were much better in their analysis, again, helped by an opinion of someone sitting to my right here. But it's a really interesting question. There have, of course, been anti-suit injunctions, foreign anti-suit injunctions that have been enforced in France. So in my view, it is not the case that this an anti-suit injunction is abhorrent to our system or cannot be recognised, or that would be contrary to public policy to recognise a foreign anti-suit injunction in France. I think there was a debate for some time as to whether the mere fact that the seat of arbitration is in Paris gives jurisdiction to the French courts, the juge d'appui, to issue an anti-suit injunction in support of arbitration. And Sylvain, I know you looked into that quite a bit a few years ago, and maybe more recently even. There's been case law, though, that has decided that that is not enough to create a basis for jurisdiction. Now, some of us practitioners may want to challenge that a little bit going forward and see whether that remains the position. The fact is that if France wants to remain an arbitration-friendly jurisdiction, And given that anti-suit injunctions are now something that parties routinely consider, it does seem a bit of a shame that we don't have a mechanism to enforce the agreement of the parties to go to arbitration. We don't have that. The only mechanism we have is indeed our local courts, who will decline to hear the matter unless and until the arbitrators have themselves declined jurisdiction. So it's a real judicial policy question, I think, as to whether our practice and maybe our Code of Civil Procedure should change on that basis. But so far, we have Court of Appeals agreeing anti-suit injunctions, regardless of what the Lugovoy law says, and we will no doubt very soon have, therefore, a series of conflicting decisions and ships passing in the night. But I suspect that in circumstances where you have a sanctioned entity, it is inevitable, indeed, that you face contradicting decisions that take a different view, including on which law to apply, including to the arbitration agreement. And so it's given rise to lots of very interesting questions of private international law, which we practitioners and academics love.
Thank you very much, Marie. So I understand that all these issues lead to, let's say, some legal novelties, either in Russian law, where the Russian law has make a kind of U-turn regarding the exclusive jurisdiction when you have an arbitration clause, and regarding anti-suit injunction as well, because I know that there was precedent in Russian case law saying that anti-suit injunctions were not allowed. So that's a new position of Russian law, and also a new position of UK law in a sense, with these anti-suit injunctions that have been decided by UK court on the basis of the applicable law on the merit, which will be the ground for the jurisdiction of the UK court. I don't know whether any other members of the panel would like to react to that. Emmanuel.
Maybe, as Marie said, it's probably past practice, but in a number of cases, the ICC as an institution was asked to send a support letter explaining that it was in a position to hear the case. That there was no impediment regarding payments, constitution of the arbitral tribunal, that we had a number of cases involving Russian and Russian sanctioned parties. So we provided such letter in a number of cases. And we know that, I think, if I remember correctly, at least one cases it worked, but we have not seen it recently.
It doesn't work anymore. The lower courts were sanctioned by the most supreme, the lower courts, who did indeed want evidence of inability to access justice abroad, that is now no longer a criterion or evidence that the Russian party needs to provide, even though we still argue it, of course.
Maybe a word about the current state of French law regarding injunctions, because you addressed it, and I tend to agree with what you said. There are two issues. One of them is whether French court would be ready to enforce a foreign injunction, and I tend to believe they would be prepared to do so. And years ago, in a case, the In-Zone Brands case, the Cour de Cassation found that an US injunction was not in breach of French international public policy, insofar as its purpose was merely, quote, to sanction the breach of a pre-existing contractual obligation. And I agree with that, and I would even go further regarding the second issue, whether French court might issue an injunction themselves. In my view, nothing in French legal traditions would be actually incompatible with the power of French courts to issue such an injunction. So, of course, we can have discussion. Would it be for the juge d'appui, for the juge des référés to issue such an injunction? This can, of course, be discussed. And there would also be a need that the court seized by the plaintiff is not the court of a member state, given the European Court's ruling in West Anchors. But this bears no relevance when it comes to Russian courts, even less so if the injunction serves indirectly the effectivity of sanctions adopted by EU law. And I think that's the key point.
I completely agree. I think that the additional difficulty maybe in this case is the only link to France was the seat. And so the question was really, is that sufficient to give jurisdiction to the French courts to issue an anti-suit injunction? And that, as far as I know, is completely untested. And the answer is, well, it's not untested, it's probably no. So I think the first test case should probably be one that has more links to France.
Yeah, actually, maybe I should clarify what I said. When I said it was possible as a matter of principle, I simply meant that it's not completely excluded.
Any other, Marco?
Well, just two very short comments on the Russian countermeasures and on bonds that we made reference to. On the Russian countermeasure, regrettably I do not read Russian, but luckily I have an excellent PhD student who is fluent both in Ukrainian and Russian, and so she's translating all the most recent cases, and it's really surprising the way that the anti-sanction regulation and legislation has been applied. Basically, whenever there is anything that somehow is related to sanction, the argument is, well, that there is a denial of the right to access to justice, therefore the Russian courts retain jurisdiction. Again, well, we are well experienced in that, because in '96 the European Union issued the Regulation 2271, anti-sanction regulation, so that's something that is also an interesting comparison. But with respect to bonds, I think you mentioned, Marie, the case where the payor is Russian, but there are also several situations, obviously, where the Russian party is the beneficiary of the guarantee, and in my experience, it's not that unlikely to be able to obtain an injunction preventing payment from the EC-based bank. But there is a huge concern by the bank concerning the counter guarantee that the European bank is giving possibly to the Russian bank, that the anti-sanction legislation would be applied also to retain jurisdiction concerning the relationship between the two banks, and ordering the counter guarantor to pay under the counter guarantee, with the possibility that the financial institution have assets in Russia that could be seized at that point. So that is, I think, one of the points and the issues that is really up there, very risky, and where, to my knowledge, there's no Russian case law yet, but I wouldn't be surprised if we were to hear something about that.
No reaction?
Just one.
Of course.
Sorry, it's for us arbitration buffs, the other reason I would encourage people to read the decisions, the anti-suit injunctions, is because of their analysis of French position on the law applicable to an arbitration agreement seated in Paris. You'd be horrified at their misunderstanding of our position. So just for those of you who have a bit of time after Anchor, read those decisions and weep.
Thank you. For sure. Okay, so you want to say something else? Okay, so we can open the floor to questions from the audience, if you have one. Please.
Yes,
oui. We have only one microphone. Vous avez un deuxième micro? On n'a qu'un?
Yes, regarding the case of anti-suit injunction, I totally agree with what Sylvain Bollet said regarding the in zone Brand case law, and I would to go in the same direction because there was some debate before the English courts as to whether the French courts would be happy or unhappy with the fact that an anti-suit injunction might be issued in England. There are anti-suit injunctions are not completely unknown from the French system. For instance, in bankruptcy matters, there is a case in 1982, I think, Bank Worms, where in very specific circumstances, but to ensure that the assets, to ensure the respect of the applicable bankruptcy principle, French court, as approved by the Cour de Cassation, issued an actual anti-suit injunction. There is also closer, and actually the same year, I believe in 2009, than Zone Brand, a decision of the Cour d'appel de Paris in the Lenovo case that issued an anti-suit injunction. It was a different case, and it was not a contractual election of four, but it was an anti-suit injunction to preserve the natural delictual forum in France, whereas an anti-suit injunction had been issued in California. But the idea is the same. It seems that our system is equipped, it's not been elaborated very much yet, but is equipped to have the natural forum either chosen by the parties or in the electoral situation, the natural forum itself respected. So either through this case law, the Cour de Cassation in Bank Worms, or anti-suit injunction, it seems to me that there is no philosophical objection to take the expression that was used by the English court in one of the cases initially, and perhaps because, I think that's what you referred to in your last observation, because the English case law, whatever the Supreme Court is going to say about it in April or May of this year, it's going to be transitory at best, because it's the only point of indirect jurisdiction now with the English court is the Senka and Shub Kababji case law that links the law applicable to the arbitration agreement to the law governing the merits, but we know it's going to disappear with the change of the Arbitration Act 1996, which now will tie it to the law of the seat. So, so that might be an even stronger reason to consider whether the time is not right now, to, given that there might be fewer possibility to get anti-suit injunction elsewhere, to see whether, in truth, French law could not do better in this respect, over and above the traditional negative effect of competence.
If I may just, no, I think I perfectly, completely share your opinion, Jacques. I think that there is nothing in French law which would prevent anti-suit injunction from the summary judge, le juge des référés, but in fact it's even more than that. I think that he can find in our French procedural law the means to order anti-suit injunction. I mean, the summary judge have jurisdiction in any case, to order measures which are justified by the very existence of a dispute. And we are exactly in this situation. And the idea, so I don't think there is, I think the French judge has the power to deliver an anti-suit injunction. I don't see why he or she could not. That's the point.
I think, again, maybe just to clarify the point.
Just to...
I teach law in Berlin in Germany, and we have the same problem with anti-suit injunctions. Traditionally, there is reluctance, or it was a concept unknown, limited to the common law world, and now it's changing, but it's actually not changing in the context of sanctions against Russia or any other country. Rather, it's changing within the context of friend licensing. And the country that is kind of the opponent is mainland China. And the courts in mainland China are very prone to issue anti-suit injunctions. German courts have answered with anti-suit injunctions. And then the Chinese courts have issued anti-suit injunctions. And I tell this story not to crack a joke, but in order to indicate that anti-suit injunctions are of limited value if everybody applies them. Everybody meaning every court. It's a nightmare for the parties who are subject to conflicting orders. One court saying you must not, and the other says you have to. They're subject to sanctions by courts which each believe that they are the Supreme Court of the world. And it's a really lose-lose proposition for everyone, I think. So I don't have a solution. I just want to pour a little water into the wine. Unless you have one tribunal court, meaning which calls the shots and ultimately makes the determination whose injunction prevails, you get conflicting injunctions, and that gets nowhere. That's happening with, well, would happen with Russia if Western European courts retaliated. Then the parties would have an injunction from this court and the other.
I mean, what's interesting about the Russian position as well is, and I forgot to mention that, is the ability not just to issue anti-suit or anti-arbitration injunctions, but also penalties. And the penalties aren't, you know, £1,000 a week for non-compliance or whatever. It is the amount that is being claimed in the forum that Russia considers not to have jurisdiction. So it's quite a drastic countermeasure, which obviously England doesn't go so far. Contempt of court is taken quite seriously, but we don't have that. And just going back to I don't think many people, or some people do, but I think wrongly doubt the authority of a French judge to issue anti-suit injunctions. I think the question is, when do they have territorial jurisdiction? And I think that's the question that is difficult, at least for the time being, where the only link is the seat of arbitration. And that is what created the difficulty here. And this is where I believe we prevailed in front of the English court, because we were able to demonstrate that in the specific circumstances of this case, it was highly doubtful that a French judge would assume jurisdiction because of the seat, but that there was nothing preventing the recognition of an anti-suit injunction, including, as you say, because anti-suit injunctions have been enforced before and issued before, albeit in very specific contexts. So I do fully expect that someone, maybe someone in this room one day, will give it a proper try to get an anti-suit injunction in support of arbitration from a French judge. And fingers crossed, we will have some helpful case law from that point on. And to your point, I agree. I think their difficulty is in some circumstances you will get that, or within certain jurisdictions. It's with certain jurisdictions you want, and so you don't have a choice other than to engage in those retaliatory measures. Because otherwise you are exposed to an unhelpful judgment being enforced against you the other side of the world.
Sorry, I don't like to ask two questions, but as a side, as a footnote to this question of anti-suit injunction, of course the point of anti-suit injunction is the anti-suit injunction, but it's the contempt of court penalty that is associated with it. If France were in any way meant or interested in this, this would have little traction if there's no meaningful penalty attached to it, because the contempt of court penalties are very strong. So anti-suit injunction is nothing in itself. It must go with the panoply of sanctions that go with it.
And what is also interesting, obviously, in the English system is that the council are very worried about continuing to defend a party that is in contempt of court, because there are real ethical obligations in that respect as well. So again, if we were to move in that direction, we may also want to look at our own ethical obligations as a matter of bar rules.
Any other reaction in the audience or questions? Okay, then we, sorry.
One more question to our Italian colleagues. I didn't quite understand your theory that the arbitration agreement is void for arbitrability in case of a sanction regime. I just don't get the theory. I mean, in the sales representative cases that you refer to in Austria and also in Germany, the basic idea was that the sales agent is the weaker party, and that the weaker party is protected by a European directive that's mandatory. And if you then have a choice of law agreement in the sales agency agreement, together with an arbitration clause, or the main decisions were not on arbitration but on forum selection clauses that designate a court outside the EU which is not applying the directive, presumably, then you take away the protection of the directive. I'm not sure that that's a convincing argument, but even if it were, I don't see how that applies or how that can be transposed to a contract where the parties define rights and obligations and then a sanction regime kicks in. Because who or how do these rights change only because of the sanction? I mean, maybe there are contract doctrines like impossibility and blah, blah, blah that may apply, but that's a merits issue. It's not that the parties can no longer dispose of it. I also don't see that one party is protected as the weaker party from being stripped of its legal position through a procedural mechanism that designates a certain court. So, what are your thoughts on this?
Just to be clear, these are not necessarily my thoughts. I have exactly your same doubts and your same position. However, I think the argument or the way in which I would expect an Italian court to approach, based on the case law that Gabriela was referring to, is that the right is no longer available to the parties, and because there might be a risk in the same line of same kind of approach of the case being decided by the Court of West Virginia and the West Virginia law in the commercial agency case. If the case goes to arbitration and the arbitral tribunal looks at sanction as overriding mandatory rules, which however are foreign overriding mandatory rules, so there is that same degree of discretion as to whether they are going to be applied or not, and that is contrary to a general interest of the state that has issued, and the court should therefore retain, in order to ensure the effective deal, which is the application of the sanction in that case. So I think I expect that would be the argument based on the case law the past case law in similar cases. Again, I was mentioning before, I don't think that is entirely justified, because there's no ground for retaining jurisdiction, but it's somehow argued on the basis of the unenforceability, supervening unenforceability or voidability of the arbitration agreement, because of the supervening unavailability of the underlying rights that are addressed by the sanction. Again, not my position, but I hope I succeeded in explaining the position.
Thank you, Marco. Any other question? Okay, so we move now to the next topic, which is the impact of sanctions on the merits. As we've heard already, arbitrators could implement or not sanctions, and we will see how that could arise. So Marco, I will leave you the floor, but before that I will have to say that you will leave us at 7 because you are heading to Vienna for the moot. So thank you for having been with us, and please.
Yes, I'll take just a few seconds to thank for the invitation, but also to apologize for that, because I hate leaving early, and I know it's not unpolite, so I apologize with the panelists and with the audience. That said, I'll try to present, again, an objective overview of the issue of the impact of sanctions on the merit, which is very closely connected to the last comment I was making, which can be described probably in general terms by using two different ways or concepts that describe the merits and the norms that are being applied. The first is the distinction between norms and decisions. Because some of the sanctions that are being applied, in this case, in particular the individual ones, have more of a structure of an administrative decision addressed to individuals rather than general and abstract norms, which is an interesting aspect which may become of interest, in particular from a private international law perspective, because unlike the type of sanctions which are general and abstract more or less general and abstract norms, because now they are becoming more and more sector specific and more articulated, but unlike those that we still consider to be general and abstract norms, the decisions are individualized and have a sort of administrative structure, which makes it less likely to be regarded as foreign rules suitable to be subject to a conflict of law analysis and possibly as an application. And there might be some problems in looking at those rules as overriding mandatory rules or foreign overriding mandatory rules which are applicable. The second dichotomy that characterizes the impact of sanctions on the merits is the distinction, the dichotomy between datum and use, meaning the sanctions as a purely factual aspect as opposed to the sanctions as norms imposed from a specific jurisdiction. The traditional approach and the approach that probably is more favorable to an arbitration-friendly environment and approach in this area would be to consider sanction just as a datum, just as a factual situation, and therefore ask the arbitral tribunal or expect the arbitral tribunal to apply the lex contractus, the otherwise applicable law, to look at the sanction as a factual situation, and therefore under the applicable law determine whether there is a force majeure, whether there is any other doctrine that could be relevant in that respect, whether frustration, impracticability, hardship, supervening change of circumstances, depending on the applicable law in the case. There may also be a possibility of looking at from a factual point of view, the sanction as an issue of validity. There is a very old English case in this respect, the Foster versus Driscoll, which 1929, which held the sale of whiskey invalid per se, because the sale was intended to circumvent the prohibition, the alcohol prohibition in the United States, and therefore, although U.S. law was not applicable and there was not even a question of applicability of U.S. law, it was the abusive intent per se that led to this kind of conclusion. And there is a sort of echo of this approach also although reversed in a way, in the Bank Medi-Iran versus Deutsche Telekom, a decision rendered by the Court of Justice of the European Union in application of the European anti-sanction legislation, which somehow looks at the merits from the perspective of the factual circumstances. The opposing view is looking at sanction as use, as legal norms applicable. And I would say that basically there are two questions from the European perspective that need to be addressed. First is whether Rome I regulation is binding for an arbitral tribunal, because then that will have an implication for an arbitral tribunal seated in the EU, because that obviously would have an implication as to Article 9 and overriding mandatory rules and foreign overriding mandatory rules. That's a question which is not easy to answer. There's not a final answer, but I think that is the question, which also will then probably bring us back to some of the issues that we were discussing before. The second quest is, again, a very well-known question: what is and how is the arbitral tribunal called upon to look at the risk and react to the risk of the award being annulled at the seat or denied recognition and enforcement? We all say, well, there is a duty to take any reasonable steps to render an enforceable award, but what does that exactly mean in a situation where there is a concrete risk that the award will be held contrary to sanction or to anti-sanction legislation? Now, I think in that respect, with with respect to the use perspective, there are three basic scenarios that may be taken into account. The first is the situation where the economic sanctions are the economic sanctions of the lex contractus, the economic sanctions of the applicable law. In particular, when the applicable law is the law of a EU member state. If we follow Eco Suisse, the case law, we would say, well, in that case, the overriding mandatory rule is to be applied. It's to be applied by the arbitral tribunal. Some jurisdiction, this does not apply only when there is when the sanctions are in the lex contractus, but Germany, Switzerland tend to require some sort of additional link between the sanction and the sanctioning state, the law of the sanctioning state, and the situation and the relationship. Obviously, this may lead to several types of conflict. The conflict between the sanctioning lex contractus and the anti-sanction legislation, particularly in the seat. Or the conflict between the sanctioning legislation and non-sanctioning states. Another issue that may arise, I'll just mention it, and then maybe someone can take that and follow up on that, is the impact in this situation of stabilization clauses, clauses that would choose the law as enforced at a certain date prior to the adoption of the sanction. Second situation is economic sanction as the law of a third state, like U.S. sanction in European member state, or in arbitration seated in European member states. Now, the easy solution would be to look at that as a datum, and therefore, what is the impact of that provision? But if we pose the question as to a use, a norm, the foreign overriding mandatory provision in that case creates the problem that I was mentioning before. Is Article 9, third paragraph relevant in this case, or is there a requirement for the arbitral tribunal to seek into any other type of close connection between the sanctioning state and the performance, or what are the effect of application or non-application of the sanction in terms of validity and possible recognition, denial of recognition and enforcement. The third and last scenario is the sanction issued by the state of the seat, other than the state of the law of which is applicable to the case. One possibility here would be to say, well, all overriding mandatory rules are in any event foreign to the arbitral tribunal. And therefore, it's not relevant that the sanctions are issued by the state of the seat, because they are foreign overriding mandatory rules, as if they were issued by a third state. And then again, we have those different scenarios, possibly considering as datum, as a factual situation, or otherwise. The opposing position would be to say, well, ultimately, the arbitral tribunal seated, it draws its legitimacy from the seat, and therefore is bound to apply. And in fact, if the arbitral tribunal does it, the award is subject to the annulment at the state of the seat. And then there is an intermediate position, which is, again, requiring the arbitral tribunal to look at the consequences, which is not so far-reaching as the second one, to say, well, you're bound to the law of the seat, but still, in most jurisdictions, it's clear that the award would be annulled. Most jurisdiction would deny recognition and enforcement of the award annulled at the state of the seat, and so the arbitral tribunal is very likely to feel bound by those sanctions issued at the state of the seat.
Thank you, Marco. So I have two questions I would like to address to the panel. So you drew this distinction between sanction being considered as a rule, being part of the lex contractus, or not being part of the lex contractus, and then considered as a mandatory rule or loi de police, and sanction as a fact, as a data, being embedded in the lex contractus through force majeure, or maybe fait du prince as well, could be considered. So I would like to know what are the opinion of the other panelists on this first issue. And there's another one, which is what about an arbitral tribunal? It's a more tricky one. What about an arbitral tribunal being facing sanctions in the one hand and counter sanctions in the other hand, or blocking statutes, for example, the EU regulation from 1996, which states a blocking statute against the US sanctions. So I would like to know what are the views of the panelists on these two issues, or two questions. I don't know who wants the floor. Gabriele?
I just had a comment, actually, sorry, I'm departing a little bit from what you asked, Matthias, because I think if I well understood the second type of interpretation of the sanctions, which is the law of a third state, for instance, how can we see what could happen if, for instance, the arbitrator is faced to the potential application of third countries' sanctions. And you mentioned the example of the United States. And that, I think, is quite connected with the decision of the Cour d'Appel of 2020 that I mentioned before, because you also mentioned the consequences of that. So I think that if the seat of the arbitration is in Paris, and the Cour d'Appel is pretty clear on that point, the arbitrators are not bound. They do not have to abide by the application of the U.S. unilateral sanctions. The reason being that they are not, they don't constitute an international consensus, so they don't fall within the scope of the international public policy, French international public policy, not, and of course not in the scope of the transnational public policy, and therefore they are not abide by dues. Now I know it's really theoretical, but
what about if the performance is entirely in the US?
And so if then it has to be enforced in the US. Yeah, the French position, I think it's pretty. It's that one, probably too theoretical, but that's.
Marie?
Just very briefly, also because I'm very conscious Sylvain still needs to address our last topic, but maybe one other potential law is the personal law of one of the parties. especially the one that is being prevented by sanctions issued by its country or regional organisation from complying with the otherwise valid obligations of the contract. So that's yet another set of rules to be applied. The other was just a brief comment on whether it's a duty on arbitrators to issue an enforceable award or whether it's an endeavour. In the case at hand, it's very clear that the award that will be issued in any of those cases will either be enforceable in Europe, non-enforceable in Russia, or vice versa. And so the arbitrators will need to choose. There is an absolute impossibility on their part to issue an award that is enforceable in all relevant jurisdictions. So there's a clear conflict of laws in that respect. You couldn't be clearer.
Yeah, I totally agree with you. And in fact, when arbitrators have to deal with sanctions, I would say that the underlying situation is that of a clash between two legal orders. The legal orders which issued the sanctions and the legal order of the targeted state. And Matthias, you raised a question regarding blocking statutes and so on. And of course, they make the existence of such clash even more obvious, but I think it exists in any circumstance because the state which is targeted will never be happy with the sanctions anyway.
No.
So the interests of two legal orders are in conflict, in true conflict, and then the arbitrator will have to take sides. I think this is inevitable. And I believe there is simply no room for a neutral attitude from arbitrators. And actually, it's been argued that there would be one, which would be not to give effect to sanctions and to stick to the application of the lex contractus. It was said by, notably by Professor Pierre Mayer in an article he published on the topic, that the neutral attitude would be not to give effect to sanctions. But in my opinion, this would not be a neutral attitude. It would amount to giving precedence to the interests of the sanctioned state, and this is something that is inescapable, I tend to believe. So arbitrators will have to take sides in the end, and I think that in the abstract, from the perspective of the arbitrator, the relevant approach would be to assess whether it's more legitimate to give effect to sanctions or not. And obviously, this is not necessarily an easy call, and it carries a risk of subjectivity. And of course, the nationality of arbitrators is going to carry a lot of weight in this assessment, I believe. But again, in the case of sanctions against Russia, for instance, we must keep in mind that arbitrators might be sanctioned if they don't give effect to European rules, and the same goes for American rules, actually. So I think that it's realistic to say that in the mind of many arbitrators, this consideration will come into play even before actually assessing the legitimacy of sanctions and the outcome of their application. And this will reinforce the effectivity of the US and EU sanctions regime. This being said, I also agree with what was said regarding force majeure and so on. It's true that the question of the legitimacy of sanctions ceases to arise anyway when it comes to assessing force majeure or such notion, because in this case the issue is whether the sanction is in fact an obstacle to the performance of the contract. And as a fact, it doesn't matter whether it's legitimate or not. For instance, if the performance of the contract was made impossible by a storm, you would not wonder whether the storm is legitimate. And I think it's the same here.
Well, I'm sorry to try to be very practical and maybe not extremely legalistic, but in practical terms, the experience we have is that an institution or an arbitrator may be obliged to disclose, or the banks of the arbitrator or the banks in the institution and the insurers might be obliged to disclose to the regulators that they have rendered an award, or they are participating even in an award where sanctions apply. And the difficulty, because we raised this with banks a while ago, and with the French Treasury, by the way, and the issue at the time we had was exactly what we discussed. And the position at the time was, we don't care, basically, you will have to report and inform us. The problem for the institution or the counsel or the arbitrator is that if the bank is not satisfied that what you do is compliant with their policy or with the policy as understood by or the EU regulations or the US regulations as understood by the bank or the regulators, they will simply close your account. This is an issue we had, with the banks. We found alternative banks, but the bank saying, it's too risky, we don't know, we don't understand what you are doing, you're telling us that you're complying with sanctions, we trust you, but we don't want you as a client anymore. So what do you do? The same with insurers. I don't know if you have looked at your insurance contracts, but look at them. Look at your licenses for this, your mobile phone. Are you allowed to deal with sanctions or to discuss sanction issues? You will be surprised. You can look also at your laptop licenses. Have you looked at the exclusions? So if you deal with sanction, you have an obligation to report. Do you do it? So you see, I agree, there are plenty of questions, there are no case law about it, but in practical terms, when you renew your applications for your IT system as an institution or as a law firm, someone has to sign the contract saying, yes, I undertake to comply with US, EU sanction and others. So if you don't, what will happen?
Yeah, thank you, Emmanuel. And it's true that it's very difficult to read all those contractual terms we are signing, even though we are lawyers. And I don't know whether there is any other reactions. Maybe as we have a little bit of time left, there is another issue that we did not address, which is the link between sanctions and investment arbitration, and whether a sanctions program could be challenged on the basis of a BIT, for example. I don't know whether there's one case at the moment from a Russian oligarch against Ukraine, and we all know that there have been some kind of expropriation in Russia for French companies like Danone and Carlsberg, and also a Norwegian media company called Amedia. So I don't know whether panelists have any views on this. Marie.
And there have obviously been cases before in investment treaty arbitration relating to sanctions. I think what is different here is we're not talking about UN sanctions. And so there will be a really interesting question as to the extent to which EU sanctions, or indeed UK sanctions and US sanctions, taken together constitute public international law that should apply to the dispute. Obviously also questions of force majeure, as it were, or the equivalent under public international law, how will that be applied by investment treaty tribunals? That might be a relevant question in those cases.
State of necessity.
Exactly. It'll be interesting to see whether state of necessity will be accepted in the case where, at least coming from the sanctioning states, it is the sanctioned entity itself that caused the sanction, and therefore, at least on a customer international law, wouldn't qualify for necessity. So there's certainly interesting questions because of the somewhat unilateral nature of the sanctions that will arise. And you're right, it goes both ways. Indeed, there are cases that are being launched by Russian entities because of sanctions being applied and assets being frozen, for example, and that can be lifted to pay arbitrators, for instance, subject to the authorization of the relevant treasury. But there are obviously cases going the other way, the countermeasures being taken, expropriations having happened in very rapid succession. Some people say that it's the kind of cases that will only be resolved once the war itself is resolved and everything is settled at political level. And it's everyone's guess how long that will take. But just from public international law perspective, a lot of very novel questions indeed.
Yeah, for sure. Any reaction? Okay. So we will now move to the last topic, which is the impact of sanction on the enforcement of award. Of course, there might be a distinction to draw between enforcement in the state that issued the sanctions and enforcement in third states. So, Sylvain, could you share your views on that?
Yes.
It's working.
Actually, I believe there are many issues, but as regards the impact of sanctions on the control of awards, the first one is whether disregard of sanctions would amount to a violation of public policy under Article 5 of the New York Convention or under a provision such as Article 1520 of the French Code of Civil Procedure. And intuitively, I believe it is tempting to answer yes, that would amount to a violation of public policy, wouldn't it? Nevertheless, if one looks at American case law, it seems that an award contrary to US sanctions would not necessarily, in every case, amount to a breach of public policy under the New York Convention. Why is that? Because there is a strong policy in favoring the recognition of awards, and the public policy exception is construed narrowly. It applies only when enforcement would violate the most basic notions of morality and justice. So this is a demanding test, and it seems that it might not always be met when it comes to US sanctions. So, of course, it would be up to an American lawyer to confirm, but this is the impression I had when having a look at a few decisions or the reports of American case law. As far as French law is concerned, some interesting answers have come from a TCMFR decision, which was issued by the Paris Court of Appeal 4 years ago. In this case, it was argued that the award violated embargo measures against Iran. And the court had to say whether the measures were part of French international public policy. And very interestingly, the court drew a distinction between three layers of sanctions, three types of sanctions which were at issue. First, sanctions adopted by the United Nations Security Council. Unsurprisingly, they were regarded as part of international public policy based on their nature and their purpose. And the court called them actually international loi de police réellement internationale. And so the conclusion was that they were covered by the international public policy defense as a matter of French law. Sanctions adopted by the European Union were also included in this international public policy. And again, I believe this is not an unexpected finding. Given the importance of the objectives pursued by these rules, it would seem more likely than not that the European Court itself would consider that member states are under the obligation to treat them as components of public policy when it comes to reviewing awards, I believe. And a parallel can be drawn with the Eco-Swiss decision, of course, concerning European competition law. Last category of sanctions, US sanctions. On the contrary, the court found that they didn't fall within the scope of French international public policy. Why not? Because there is no international consensus in their respect. And furthermore, their extraterritoriality has been subject to criticism from the French authorities and also from European authorities. And in particular, I think that the reference made to the notion of international consensus is very interesting because it tends to become a criterion by which the Paris Court of Appeal assesses whether foreign mandatory rules are part of international public policy under French law. So I believe this reference to the notion of international consensus is pretty significant. Assuming public policy and international public policy is at stake, the next question is how far the review should go. Should the award be reviewed on the merits, or should there be some deference to the arbitrator's findings regarding the applicability of sanctions? In my opinion, one should expect in France a full review. Why is that? Not because of a particularity of sanctions, but because this is the general trend in case law concerning the review of awards on the grounds of public policy. And this flows in particular from the decisions you certainly all know, which were rendered by the Cour de Cassation in Bellocon and Sorelec. So this control should make it possible to set aside an award where the arbitrators have satisfied a claim, whereas a sanction regime prohibited such satisfaction. This being said, the opposite scenario might also arise, and here comes the question. What if the arbitrators have over-applied sanctions? For instance, they decided that a claim is inadmissible based on a sanctions regime, whereas in actuality the situation did not fall within the scope of the contemplated rules. In principle, this type of mistake should not give rise to the annulment of the award as a matter of French law. Because according to a well-established case law, the court can only annul an award in the event of a concrete violation of public policy. This means that the very purpose of the mandatory rules at stake must have been breached. And this goes only one way. For instance, as regards EU sanctions against Russia, the rule of inadmissibility I mentioned earlier requires that certain claims be not satisfied. But the concern, the purpose of the rule is not that all other demands are satisfied. This is something different. And I would say that the sanction regime in itself has simply no concern, no actual concern for this dimension. And as a result, if the arbitrator wrongly decided that the inadmissibility rule applied, then there should be, as I see it, no ground for annulment. But maybe there is a caveat. The party seeking annulment could still argue that the award, as it held the claim inadmissible in this scenario, gave rise to a denial of justice. And from this perspective, it unduly infringed its fundamental rights. And this could also be a violation of international public policy. This type of argument was raised actually in the Fincantieri case. And ultimately, the argument of denial of justice was rejected both by the Paris Court of Appeal and the Cour de Cassation. This does not necessarily mean that it could be successful in no circumstance. In that case, in the eyes of the Cour de Cassation, a key element was that the Republic, which had brought the action for annulment, had been able to discuss the scope of sanctions before the arbitral tribunal. So there was a discussion before the arbitral tribunal. This was a key point. So, of course, from the perspective of arbitrators, this should be an aspect on which they have to pay attention.
Thank you very much, Sylvain. There is something I would like to add to what you just said when you described the solution that has been rendered by the French Court of Appeal, the Paris Court of Appeal, regarding extraterritoriality. It's true that extraterritoriality has been a big issue in sanctions. I mean, before the Russian war, the Russian invasion of Ukraine. But I'm wondering whether it is still an important issue for the European courts and for the French courts and any EU member state courts, because now the European sanctions are extraterritorial as well. So, I mean, the EU has been strongly against extraterritoriality, but now since I think that there was the 12 paquet programs, sanction program, now there is an extraterritoriality at the European Union.
Actually, maybe I should clarify what I said. I don't think the problem is that of extraterritoriality in itself, but in the case of US sanctions, there has been diplomatic tensions around them because the way they were applied quite broadly in the eyes of European states. It's something which gave rise to objection, from the European side. Mm-hmm. But I agree, extraterritoriality in itself is not something that is necessarily open to criticism. And I would also say that it's always difficult to define what extraterritoriality is. What is territorial, what is extraterritorial? Sometimes it's also a matter of presentation.
Mm-hmm. Well, it has been seen at level from a European point of view, but now it might be a bit different. But I don't know whether the other panelists would like to react to what Sylvain has just been saying. Gabriele.
It's not strictly related to what has just been said, but it's a correlation between the recognition and enforcement of awards and investment arbitration, the case of investment arbitration. And while I was listening to the presentation, I was thinking about a case that surprised me quite a lot. It's quite recent, I think it was from last year. It doesn't have anything to do with the sanctions, but it was a US district court rejecting the enforcement of an award between a unilateral investment award between Dutch entities and Spain, based on the fact that the arbitral tribunal disregarded completely the application of EU law, that did not allow basically to have an investment arbitration between these entities. And it's very, I'm just, nothing is concrete, but it's just in theory. I was thinking what happens, for instance, if we have an investor state case, we have one of the the seat of arbitration is in Italy, where according to the sanctions, if sanctions are applicable, the arbitration agreement is invalid. And that was exactly the same argument that the US court advanced when it says that the arbitration agreement was invalid because investor state arbitration is not valid in the European Union. Then if we have that case, and then we have an award because the arbitral tribunal does not disregard completely the existence of the sanctions, what happens is then, if then the award is going to be sent to US courts, are US courts going to accept or not? It's just a question.
Mary, you want to react?
Get me started on the Spain cases, you shouldn't have. But it's not just in the UNCITRAL context, even in the ICSID context, there's an obligation on all contracting parties to enforce the monetary obligation under the awards as if they were issued by a final court of their jurisdiction. The position of some courts is to say, but even if it's a final decision in France, it needs to be compliant with EU law, for instance, and therefore the final arbiter is not the French Court of Cassation, it's the ECJ. And there's still a level, even at the recognition level of an ICSID award, where there will be a review of something that is completely foreign to the ICSID system, and where national, regional laws, or indeed a certain concept of public policy may come into play. Obviously, there's been the Mikula saga, etc. But I do agree with you. I think there's a real question mark over what might happen to those awards. And I can imagine a jurisdiction thinking it's abhorrent to give effect, even under the ICSID Convention, to an award that is contrary to the sanctions issued by the regional organisation, which it's part of, indeed, it's federal state. And again, we'll come to an interesting interplay between a state's obligation under multilateral treaties, such as the Washington Convention, and how that's interpreted, and its own obligation towards its government or legal system. And unless and until one of the contracting parties to the Washington Convention then implements the state-to-state dispute resolution mechanism, there will be those uncertainties, however final we think those awards are.
Emmanuel, do you want to like to react? No? No.
Maybe just one point, Siva, on inadmissibility. Very interesting what you said. Obviously, agree with you. It wouldn't be reviewable other than under the lens of a breach of public international policy. And this is where framing a question as one of lack of admissibility rather than lack of jurisdiction comes to bite you at the end, because obviously the jurisdiction would be reviewed de novo in front of the Paris Court of Appeal if this is how it had been framed, and indeed if this is how the award had been then decided on the basis of lack of jurisdiction rather than lack of admissibility of the claim.
Yeah.
Did you?
It's true. It's a difference between jurisdiction and the rest. Jurisdiction issues are fully reviewed, and actually they have been fully reviewed for a long while in the French case law. But I would say that considering the new case law, which flows from Bellocon and Sorelec, the gap is really narrowed, isn't it?
Yeah, I totally agree. Okay, any other reactions from the panel?
Well, maybe something which was when again discussed between the ICC and the French regulator, which has an impact on the possible impact on the enforcement of awards. it was considered by the French authorities to be necessary at the stage of the scrutiny of the award, which is a step that exists in the ICC system, not in all institutional arbitration systems, but in the ICC system, the draft award will be reviewed by the ICC court and based on the recommendation of the Secretariat, the court will look at the matter and will convey a number of comments to the arbitral tribunal before finalization of the draft and execution of the award by the arbitrators. It was felt that at this stage, the Secretariat had to raise the issue of sanctions and impact on enforcement as a routine. You know, because at the beginning, it was at the time of the Iranian sanctions, but a number of tribunals took the attitude not to raise the issue. And it was obvious that the case, you know, was somehow impacted by sanction, but it was not raised by the arbitral tribunal in the award. And the position of the French authorities at that time, and since has been to say, well, it should be raised. So the institution has to raise the issue with the tribunal. Tribunal is at liberty to decide whether to, how they would respond to that request, but at least it should be mentioned.
So during the scrutiny process, it was raised. It is raised by the institution. Okay.
Yeah. And also, at the stage of enforcement, what we see is that sometimes when asking for copies of the award, for example, the parties trying to enforce an award will, for example, ask for a kind of support letter saying, was this issue raised? Of course, we cannot breach confidentiality, but saying, yes, the standard process was followed, and pursuant to the ICC rules, you agreed to comply with the award.
Okay. Okay. Gabriele, you want to add something?
I was just saying, I was thinking that the exercise is interesting, but it may be limited sometimes, because if, I mean, the institution doesn't have, of course, a clear view of the entire file, and let's say the parties do not raise anything, or just raise a very single reference to a legislation, I don't think it's for the institution to go, you know, investigating the issue. It's the same for corruption or money laundering. Mm-hmm. It's, I mean, unless there are clear red flags for sanctions in this case, the institution cannot do much, I think, and logically.
Yeah, but if you draw a distinction with a comparison with corruption, I mean, I'm not talking about the institution regarding the French court, at least, even though the corruption hasn't been raised during the arbitral proceeding, it could be raised during the enforcement proceeding or the setting aside proceeding. So I assume that it is the same, or not, I don't know. Sylvain, what do you think? Is it the same?
Yeah, I believe it would be the same. I agree with you.
Mm. Any other reactions? Let's open the floor to questions. Thank you.
Could I invite Cornelia to elaborate on what he said, if I understood correctly, that maybe I should backtrack for a second. When it comes to corruption, we all know that in the state of the current case law, corruption is a non-starter, so I would expect the ICC court, when witnessing a situation of red flags that have not been noted by the arbitral tribunal, to stop the draft award from ever being issued. But then when it came to sanctions, you indicated, if I understood you correctly, that the French authority are requiring the ICC court to raise the issue of sanctions with the arbitral tribunal that did not know the issue. Did I understand you correctly?
Yes, the request was simply to make sure that this was part of the discussion.
How do the authorities know that?
Well, because to get an authorization to process cases, you know, the problem was to try to define, because of the scope of activity of the ICC and the difficulties to make sure that, well, basically we could administer arbitration proceedings in France and elsewhere. There were discussions between the French regulator and others in Europe and in the US. So they had to come to an agreement about how ICC arbitration could work in practice and how the Secretariat and the court could work. And the solution was that when there was an issue of sanction, to make sure that this was addressed by the arbitral tribunal. So the Secretariat has to, well, the court has to convey the point to the arbitral tribunal saying, we believe that the case, and it's already in the system. I mean, we already know when sanctions are, most of the time, when sanctions are involved, to make sure that this point is raised at the scrutiny process. So asking the tribunal, the case was flagged as raising sanction issues. Do you think that it should be raised, or did you discuss it? We don't know to investigate, as Gabriele said. We don't have the means to investigate and to find a solution. But we should raise the point with the arbitral tribunal, saying, did you see it? And most of the time it's obvious, because most of the time it has been discussed. And most of the time we don't need even to raise the point, because it's already mentioned. If you have to change currency, it's obvious that sanctions have been considered. But this was, I said, at the time where we knew very well, there was, years ago, more than a decade or 2 decades ago, there were a series of cases where, for example, when we had a contract involving the territory of Iran, the mention of Iran in the award or in the parties' submission would be deleted. And when we had this type of issues, we because of the implication for the ICC and also for the arbitrators and for the banks and the insurers, for all stakeholders, when we discussed that with the authorities, they say, well, your duty as an institution to get the permission to process cases would be to make sure that the issue is identified and raised with the tribunal. So that's what we do, and it's very transparent. It's in the notes on compliance on the court website. We explain to the parties that, and to the arbitrators, that if we see this type of situation, there is a possibility that the issue would be raised with the arbitral tribunal.
And would you consider that the ICC is duty-bound to file a suspicious activity report with the financial authority in France?
No. Well, we have an obligation to report if the award is in favor of a sanctioned party. So that we have an obligation to report.
But the money is not going through you. There could be awards.
Yes, I know.
Yeah.
I know, but we have, because of the potential implication at the enforcement stage, we have an obligation. If an award is rendered, let's say, to the benefit of an oligarch, we will have an obligation to notify the French Treasury that the award has been rendered.
Any other question? Please speak in the microphone
My question
in order
was actually to Emmanuel as well. Oh, I'm sorry.
Yes.
Okay. No, my question was to Emmanuel as well, and on the same subject, but it's a continuation of the prior question. So in the cases where the ICC court, as I understand it, drew to the attention of the tribunal that questions of sanctions should have been raised where they were not, what did the tribunals do? Part of the answer, as I understand it, might have been that it was already part of the matière litigieuse, it was already discussed, in which case that's kind of easy for the tribunal to add something. But what if it has not been discussed? Did they reopen the proceedings? Because then there could be a violation du contradictoire if they did not. What happened concretely after the court did this, when it did?
Well, I remember an old case where this was, for example, where this was discussed at length with the sole arbitrator, and the sole arbitrator decided to reopen the proceedings on this specific point. But most of the time, in fact, it's simply a question of drafting. What we see is that almost inevitably that would have been raised, orally or in the pleadings. You will find something. And the arbitral tribunal considered that it was not really important, or that was so obvious that it was not necessary to mention it in the award. But in practical terms, we almost never have difficulties with that. Or we no longer have difficulties, should I say.
I wanted to come back to a point, maybe you addressed it, but I don't remember, sorry if it is the case, of the situation of the arbitrator who is likely, who could be impacted by the sanction in a way or another. So depending on the decision he or she may render, he may be impacted by this sanction. Alors, is it in such situation, even if it is a tiny risk, shall the arbitrator resign if he comes or she to this conclusion, or a challenge? I mean, shall a party, enfin, could this arbitrator be challenged for that very reason? You know, each time, because you said, I think, that depending on the solution, an arbitrator might be concerned by the sanctions, because, okay, so if it is the case, would that not impact its freedom of judgment? And for that reason, shall the arbitrator systematically resign if he or she comes to this conclusion? Well, that's
There is another option, which is asking for a license.
Yes, exactly. So we had, in statistical terms, we had very few cases where, in this type of situations, the arbitrators resign. We had very few cases, a handful of cases. Because most of the time the discussion will occur before, at the time where the arbitrator is proposed by the parties, and the arbitrator will discuss with the secretariat saying, should I accept the case? What kind of guarantees could I have? Or it's discussed at the stage of the terms of reference. We had a case, an interesting case, where the arbitrators ask the parties to sign, to accept a provision in the terms of reference according to which the arbitral tribunal would be held harmless and indemnified if they were sued for issues related to sanctions. Most of the time, arbitrators will, first of all, and I think that's the right attitude, discuss with the secretariat. And we see a change. You know, years ago, arbitrators almost never discussed the issue. Now they do, I think, which is right thing to do. They will discuss with their insurer also, which is also the right thing to do. And a number of arbitrators have applied for a license. The difficulty in practical terms is that in many situations, the authority in charge of granting a license, first of all, will not respond immediately. It takes usually months before we get, an answer. When the institution contacts the regulator, it takes less. In France, for example, we have a kind of special channel with the French Treasury, and we get answer relatively quickly, but nevertheless, it takes some time. But the difficulty is most of the times the regulator would say, we don't see the problem, there is no issue for us. So it's not, not helpful. Because the problem is that, and we also had the issue where the banks, for example, insisted to have a document from OFAC. And OFAC said, but there is no US sanction. The bank said, well, in the policy, the conditions, or my conditions of your account, you need to have a license from OFAC. And OFAC said, but it's not sanctioned. What could we give you? So, no, but it's extremely, I'm sorry to say, it's extremely practical. But we had issues with some arbitrators, or for ICC payment, for months about that. And finally, as an institution, it's not the arbitrator, but as an institution, we got a document from OFAC saying, yes, what you do is licit. But it's a nonsense. Having a document saying what you do is not illicit, why are you applying? And if it's revoked, because that's the point. OFAC licenses or these kind of documents have a limited duration. If it lapses, then the bank will say, is it because your activity is more risky than before? You know, so you enter into a number of discussions and difficulties. But my inclination would be to say, discuss with your insurers, discuss with the institution, and most of the time, as I have said, you know, in terms of statistics, most of the time we manage to find a solution.
Any other questions? Yes. Merci, Marc.
Thank you so much for a lot of food for thought. I have a quick follow-up question on the inadmissibility rules that you mentioned. On its source, exact meaning, and probably imperativity. So when you say that there is an inadmissibility rule, in which sense do you use the word inadmissibility? In the sense of French civil procedure, meaning dismissing the claim before going to the merits, or in a larger sense, meaning just dismissing the claims? Because a lot of sanctions texts do not provide for the exact legal consequence of inadmissibility. They just say the claim shall be rejected or the claim shall not be admitted. So where do we draw this inadmissibility rule? And in the case where the text provides for these exact sanctions of inadmissibility or irrecevability, would an arbitrator that would go for an alternative sanction, such as dismissing the case on the merits, violate the international public policy? Thank you.
Who wants to answer this tricky question? Sylvain.
Actually, I refer to a specific provision of, for instance, Regulation 833/2014. It's Article 11. Actually, I have it here, so maybe I'm just going to read it, and you see how it is shaped. No claims in connection with any contract or transaction, the performance of which has been affected directly or indirectly by the measure, in all or in part, by the measures imposed under this regulation, and so on, shall be satisfied if they are made by entities referred to in points, and so on, any other Russian person, entity or body, and so on. So, you know, this is, as I see it, relatively clear. The claim cannot be satisfied, and you're not going to assess it on the merits. You're just going to see that it falls within the scope of the sanction regime and the considered rule, and you're going to say, no, we cannot satisfy this claim. I don't think this is a matter of jurisdiction, properly said. It's, as I see it, this is what we would call, as a matter of French law, fin de non-recevoir, and this is why I said it pertained to admissibility.
But I think we're set now, and I'd just like to say a few words in order to conclude. I think I told you at the beginning that we were having an outstanding panel today, and you can now testify that I did not lie. We are all about to leave the room with a much better understanding of the issue. So before heading to the next room where there is a cocktail, I would like us all to congratulate our fantastic panel today.